Hi, Ellen.
Hello again. Ellen Czajkowski, Office of Legislative Counsel. Good afternoon.
Good afternoon.
Where were we?
Cafeteria.
I think we were talking about criterion 8 and forest blocks and connecting habitat.
Yes. And we're going to look at joint language and ours, and possibly hear something from someone in the audience. I thought. Maybe not.
No, we weren't.
Matt Chapman comes to mind.
Name out of a hat.
Since you're not volunteering, I'm not volunteering.
Well, sure. I'm not. I apologize. I'm not sure what the committee would like to hear from specifically. I mean, so there was. So for the record, Matt Chapman, General Counsel, Agency of Natural Resources. So over the weekend, there was some language circulated around that gave additional clarity and guidelines. Those were provided to Ellen. They basically require that the board adopt rules and that those rules speak to how people determine where criterion, specifically 8C, but also B applies, and sort of how the process works underneath them. And I apologize, I don't have copies, but I can forward it to Mark and the members of the committee if you would like.
Well, are you finished describing it?
Yes, that is generally speaking what it does. It takes the criteria that are in your proposal, scales them down, and gives the board a little more discretion in how they go about doing those things, and then tells them that they need to both convene a stakeholder process on how to conduct the rulemaking and then adopt the rules.
How to conduct rulemaking?
Convene a stakeholder process to sort of get pre-rule information from people who have an interest with respect to the wildlife criteria before the rulemaking actually begins.
So I guess, committee, our question for us is that the direction we want this section to head? And if so, we can move on and let Ellen incorporate that? Or if there's another proposal on the table, I'd like to hear it.
Incorporating under the.
Yep.
Well, I do appreciate the rulemaking process because of the role of the public hearings and the value that provides. I also think our language provides a little bit more clarity about what we mean about avoid and minimize. I think we heard convincing testimony about adding mitigation there, and perhaps the focus on what that mitigation looks like for under a rulemaking may make sense. But I do appreciate the kind of the clarity that our existing language provides. I mean, what we're talking about here are the critical focus of this is how to prevent the impacts of fragmentation on the last remaining forest blocks and connected habitat, and that's absolutely essential to how we think about Act 250 moving forward. And so while I think it will accomplish the objectives of the joint proposal in providing and understanding the steps necessary to determine that a proposal is not causing any undue adverse impact on these highly valuable natural assets, I think our language achieves the same purpose, but with more clarity. my proposal is I favor keeping the original language with an addition of adding mitigation.
What?
In
The
adding
addition of what?
mitigation?
Then adding the mitigation piece to it.
Our original language, committee bill.
So the thing that I gave the thumbs up to that Trevor said, I'm second guessing myself, but I'm thinking it was our language with their addition. Is that, so I'm questioning.
Well, they want rulemaking and ours doesn't currently have rulemaking.
There's that, okay, and they had some more, the rulemaking was to determine the specificity, like,
Right.
what does this mean? It will mean citing your project next to existing boundary lines, blah, 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 blah. I think, is what the rulemaking would come up with, that sort of thing.
Yes.
Yeah. Well, I like our original language, and I like the addition. I'm thinking they can be merged, and that's what I was thinking we were doing.
I'm not sure what you mean by the addition.
The new language that Matt Chapman is proposing, which I haven't really seen yet, but
Okay, but without seeing it, it would take it would take their C and say, board, go promulgate rules,
Yeah.
and it would use
okay.
some of our specific language to help drive the rulemaking.
Yeah.
Or are we just like, we don't need rules, we're ready to go, this has been vetted?
Where's the mitigation thing?
Well, we've agreed to add mitigation to ours.
Okay.
So mitigation, I think, is gonna go in, we've agreed to that.
What do you think is more protective of the environment?
Theoretically, they should both be, it's just whether or not we're ready to implement it kind of now, under the guidance that's in ours. Ours would still probably need rulemaking for mitigation. But that would presumably be less than rulemaking for the whole thing.
Well, I presented this, or at least part of this bill on the floor 3 years ago now. And the memory has it there were significant questions about what does this mean. And you know, my answer was, well, instead of putting a house or in a long driveway or 20 houses in the middle of the property, it goes next to the stone wall by the property line, blah, so on. And our language, I don't think really speaks to that, and that does, I think, leave it up to interpretation by the various boards, and so I'm thinking I'm sticking with Trevor.
Which way is Trevor going? I forget now. I'm sorry, I just forget which way
I didn't
was
hear
on
what you
that.
said.
Well, it's kind of hard to hear him also, so restating wouldn't hurt if you would, for me.
Well, I was just saying we should go along with the proposal that's been offered to us,
From
Yeah.
from the administration.
which includes a rule mitigation.
And our definitions.
Yes, in our
And our
definitions.
definitions.
I just lean toward the committee though.
Okay.
Whatever.
All right, let's have Ellen see what they've brought to us and put that in the next draft.
That's perfect. I'd like to see it.
go next? Would you like to revisit environmental justice, or would you like to move? Is it Evan's turn?
Yep.
Oh, if you, are you ready to share any environmental justice wisdom that you've gleaned?
I can definitely do that.
Thank you.
What else remains for us to do, Ellen?
We are on we're on 58, but we only have to get to page 70 something.
Ease.
We only have to, because after that gets into the appeals structure. So we only have to make it to the appeals, which I think is on page 77. So we have so after that we have permit conditions, capability and development plan, relating the other planning issues, or discussing the other planning issues. Burden of persuasion, release from jurisdiction, prime ag soil mitigation. Yeah, and then planning.
Which a lot of that we've covered already. So let's do, I mean, this will be a second or third time through it. Let's do environmental justice.
Okay, so Evan Meenan from the Natural Resources Board. So before the committee broke this morning, we were discussing the newly proposed criteria 9N, which dealt with environmental justice, and both myself and Matt Chapman from the Agency of Natural Resources, I think it was Billy Coster from ANR, flagged the concern that the phrase group of people in the proposed language could be problematic because it could theoretically refer to any group that organized itself for the purposes of challenging a project. And we suggested that perhaps this language instead either reference or specifically list the types of protected classes of people that the committee was interested in protecting. That led to a discussion of, okay, well, what are those classes of people? So over the break, I went through the statutes and consulted with via email with the director of the Civil Rights Unit of the Attorney General's Office to figure out what are these classes that exist currently in Vermont. The statutes that we took a look at were 21 VSA 495, which deals with unlawful employment practices, 9 VSA 4502, which deals with housing discrimination, or really discrimination in any place of public accommodation, and then also 21 VSA 495I, which deals with employment decisions based on someone's credit history or credit report. I sent all three of those statutes to Representative Sheldon, Attorney Czajkowski, and Mark Grimes. The list of protected categories that we identified in those statutes are, and I also sent this list to all of those same people: race, creed, color, national origin, marital status, sex, sexual orientation, gender identity, disability/physical or mental condition, religion, ancestry, place of birth, age, crime victim status, HIV-related blood status, and credit history/credit report. What was not specifically enumerated was the category of persons that Representative McCullough was interested in other words, socioeconomic status. However, that could easily be tacked on as the 17th class in that list of 16 other classes. The way that the statutes that pertain to these classes are currently organized is they just straight up separately list them. It's not like there's some cross-reference to a standalone list that exists someplace else in statute. It just says something like, no employment, no one shall be denied employment because of race, class, et cetera, et cetera, et cetera. So theoretically, this list could just get plugged into criteria, the newly proposed criteria 9N. That's what I discovered. And again, that was all reduced to writing and submitted.
You said you sent that list of those classes?
I did, yes.
Oh, yes, and that's the list.
Oh, right there, yes.
Yes.
You have that piece of paper?
I'm gonna post it right now. Would you like a piece of paper? This is it.
So I might have missed your punchline, but the way the other statutes, this isn't a definition?
No, it's not. It was interesting. I thought that it was going to be some sort of standalone list that the other statutes might just cross-reference, but that's not the way they're set up. Instead, each statute that attempts to protect these people just separately lists everyone who's protected, which is also interesting because the lists are not actually entirely synonymous. So some classes get protection for employment decisions while others get public accommodation protection. You'd think there would be one solid list, but there isn't. They just repeat themselves in each statute, which is an approach that this committee could decide to take in Criteria 9N if it wanted to. Or it could just create a definition.
Evan, would you expand a little bit on the definition of social economic? Does that basically mean poor people?
Well, theoretically, these classes are supposed to be all-encompassing. So, for example, it would be inappropriate to discriminate in an employment context. It would be inappropriate to discriminate against someone who's African American. It would also be inappropriate to discriminate against someone who is Caucasian. So, for socioeconomic status, you would have to decide as a matter of policy: do you want to just prohibit discriminating against people without a lot of means, or would you also want to prevent discrimination against people with a lot of means? Should it cut both ways or not? That's a policy decision.
So, I believe our bill still has in it a study report back on this issue. So, if we're ready to have a new criteria in and feel like we've learned enough and taken enough testimony, we should continue this. But that's always there too, that's in the bill.
I appreciate that work, thank you. And by all means, I think all of us agree environmental justice considerations need to be integrated in here. What comes to mind is, and perhaps it's beyond the scope of this, is whether there's an injustice related to projects that are cited in smaller rural communities with less means to participate in that process. And I just put that out there, and maybe it can't be resolved at this point in time. But I'm concerned about the ineffectiveness of our rural communities in being able to weigh in on projects that may be well-funded and from beyond our borders even. I don't think it should be included in here because of the importance of what environmental justice does. I don't want to complicate it, but I just do mention that as something that I don't know to the extent to which we've addressed this.
So, tell me here, what are you sensitive to then? What don't you like?
Just thinking about, in the context of Act 250 projects, whether the citing of them in rural communities of limited means,
So
whether they have the capacity or the ability within, even in the context of the criteria in front of us, whether there's an injustice there or a bias that's embedded in.
So whether or not environmental justice should be included in an active.
Yeah, and I think it's beyond environmental justice, but it's still an injustice that I wrestle with as to how to address that.
It might be easier to get a project done in Island Pond that nobody wants than it might be in City of Burlington.
That's what happens now.
Yeah, and that's what.
Yeah.
That's what I don't like about it.
And that's what she was addressing, concerns.
But I guess you're saying that, and now I understand, but you don't think it's covered by this criteria?
Well, the list that we saw is absolutely important for us to be thinking about classes of people. What I'm talking about is that, about the rural communities and the whole town where it's disenfranchised.
I'm wondering if our
because
current
of
language
its-
gets to that.
Sorry?
This might get to your point.
It
and
could,
not to
it
the-
could. That's why I raise it in this context, but.
Does it need to be more
It
specific?
may not get to the group of, or the protected classes. I think the current language doesn't have protected classes of people, but it may be more to the point of what you're making. Like, if an entire community is negatively affected by a proposed
Because-
development.
Because of its rural nature, it doesn't have the means, it's poor. It could be there, we could add that, no group of people or class of people or small rural, community or something, community condition, or the economic or socioeconomic,
Community
or rural
condition.
nature. I don't know how to,
Community condition.
community condition, yeah, something.
Jim?
I appreciate the work over the lunch break, and we could add that list and then add socioeconomic, disadvantaged to that list. And the minute somebody has to come in and say, we're a group of socioeconomically challenged people, I think ours is fine, just the way it is, and we have a study commissioned. Yes, did I hear you say? I don't want to tear the study out. I think there are people who know more about it than the 25 or 35 of us in the room right now, and so I like it as is with the study.
Okay. Other thoughts on this one?
Well, could we add just no group of people or municipal jurisdiction?
Within a municipal jurisdiction.
Yeah, just after no group of people, and say that will bear a disproportionate share of the negative environmental consequences.
Yep.
Good. Yeah, do.
Or, what
No
did you
group
say?
of people
No group
or
of people or.
municipal jurisdiction.
All right,
Within
I like that, I like
Or municipalities.
Municipality.
Yeah, the municipal.
Now say that you don't like it.
Something.
You know,
Do you ever get that?
everyone-
I'm saying everything I have in my mouth. Everyone goes the other way.
I would only respond by saying that, you know, there's some projects that are slated to go into a community, and there's so much controversy, then they hold a referendum. And so no matter what, in terms of how you put this into this context, you know, it's a political decision is made as to whether or not, like industrial wind towers was very much, in my neck of the woods, was voted on by more than a number of communities on different projects. And some passed and some did not. But I'm just saying that it's kind of, if you're for it, then you figure you were glad to see it pass, and if you were against it, you were glad to see it fail. I mean, it was such a, I don't see the justice in either one. It's just a question of how you thought the impact was going to be on the environment or your life.
But sometimes these communities may have not liked it, but the financial enticement was such that it changed their mind. It wasn't necessarily what they really wanted, but couldn't afford to go the other way.
How's that different than anything else we vote on? But I'm just pointing out that it's, you know, there is a political mechanism now that determines whether or not a project is desirable.
Through local referendum.
Yeah, through local referendums. I don't know. I'm just,
But you're not suggesting that it would replace this?
no, but I'm just saying it's there.
It's there, yeah.
Yeah.
And it works.
Okay, are we good on that and adding or municipality? the local and regional plans from last time we
Yeah.
went through it.
We're done with the criteria. As far as I know.
Kidding.
So now we're on page 59. Permit conditions. The bottom of page 59, line 18, starts the addition of language for forest-based enterprise permit conditions. Do you want me to read through this? Okay.
I'm looking for the list of A&R permits that I was sent.
Oh, this is permit condition. We're not quite there yet. So you have time. So permit conditions on a forest-based enterprise. A permit condition restricting a forest-based enterprise's hours of operation shall only be imposed when the absence of the condition, I'm going to add of, would result in an impact under the criteria pursuant to subdivisions 1, 5, or 8 of this section. So criteria, so air, traffic, aesthetics.
Include noise.
Noise, aesthetics, and
Oh yes, noise is under both 1 and 8. Permits issued for a forest-based enterprise shall allow the enterprise to ship and receive forest products, including delivery from the forestry operation to the enterprise, during hours outside permitted hours of operation, including nights, weekends, and holidays, for a minimum of 60 days per year, unless there would be an impact under the criteria pursuant to subdivision 1 or 5 of this section. In making a determination under subdivision 2,
Yes, Jim?
I have repeatedly asked for clarification of the language about minimum of 60 days. I think we've been promised better language than that, or something at least this kid could understand. And it may have slipped by me, I don't know, but that's counterintuitive for a minimum of 60 days to me, and it was going to be explained by somebody. Likely it's in the room, I don't know. Does the committee understand that?
I remember when you said that, and I could use further clarification.
Yeah. Seems to me it would be for a maximum of 60 days, but
Trevor?
Well, just to follow up on Jim's comment, we were told that we were going to get new language.
yeah.
I think from Forest Parks and Rec people around this issue. And we haven't seen that.
Okay, they're not in.
We haven't seen it, and I would say that on page 27 of our commission report, it summarizes in the last 5 years there have been 7 Act 250 applications for wood processing facilities. All 7 were granted permits. The average length of time to receive the permit was 110 days. Only 1 of the new permits contained conditions related to traffic. 2 of the permits contained conditions related to hours of operation.
Yeah.
We don't need that.
Yeah, so it's not a
So I have a suggestion, which is, would it be helpful, does the committee think it would be helpful? There's a paragraph here that I read this morning about the importance of the forest products industry to other goals in Act 250. I mean, I think a sort of a positive statement of findings around that might help commissions when they're making their decisions about this, or the board, understand that there's a bigger context in which to review these, but it does sort of seem like a solution without too much of a problem.
I'd feel more comfortable with that. We don't have the language that we asked for, but even if, but the thing is, we don't know what this will mean and whether it's micromanaging something that'll change, so I like your idea.
I can't find my paragraph, but I know it. Where did it read?
So, on line 9, maybe?
On line 9 of this,
Yeah.
making a determination.
Yeah.
Consider the benefits of forest products, thank you. I think that paragraph would speak to the importance of the industry to other goals without micromanaging permit decisions.
And impose the minimum restriction necessary to address the undue adverse impact.
I like it.
Yeah. How come I never
How much
saw
more
that?
minimal could you be?
Yes.
So this, for a minimum of 60 days, they're, as I read it, they're saying, Jim, that you have to give them at least, you can't say you're only gonna do it one day, we've gotta give you at least 60 days.
Yeah.
That's no less than that.
Yeah, and what if they don't need 60?
That's-
I think that's backwards myself.
But if we went with a max of 60 days, what if there is, everything is, the stars are aligned just right and they could do what they want to do for 120 days. But we've got to give them at least 60 days. That's what it's saying, correct? And that's, I agree in that sense.
Yeah.
It should stay minimum.
Yeah.
You know, in the testimony I've heard in the past, it was sometimes, so the logging operation got a permit to go forward.
Yeah.
And then a neighbor down the road who didn't like hearing these trucks go by at 10 or 11 o'clock at night was upset and petitioned that a condition be imposed. And you know, basically that's kind of what happened. So it was always an add-on, it seemed to me, because either maybe someone who moved into the area just wasn't used to hearing logging trucks, didn't want to hear logging trucks, thought they shouldn't be given that kind of privilege and didn't want that to continue. And the commission, you know, responded to the complaint. And I'm thinking we were trying to get away so that they've got a little more flexibility here, so that that's not going to be sprung on them once this permit is granted. And I was hoping that basically that would, you know, signal what the state or what we are trying to do to help this industry continue and be a working lands industry, and we know it's in tough shape. You know, that's why I like the 60 minimum.
Carrie?
Yeah, I agree with Representative LaFave, Representative Morgan. I think also if we have there is an unless clause here, so that if 1 in 5, I believe, refer to noise and traffic, so if things are super egregious, then there's an opportunity to kind of ensure that the permit conditions reflect that. But I agree, I think this language, the permit holder can always reduce that it's the permit condition that has that, allows for it at a minimum of 60 days, so.
You know, there's a lot of, goodwill usually. I think people try to be accommodating to one another, especially in rural areas, you know, and I hate that constantly undermined it by disbelieving its existence. I think if I was so bothered, then I'd go up and say, hey, you guys can, you know, my wife just had a baby, and my grandfather's very ill, and people respond to that. I've had it happen to me. So, you know, I don't know. I think there's room enough, and there's margin enough, and there's flexibility enough, so that, you know, the 60 minimum to me that works without changing it, and hopefully that you know, we can get along as far as the logger goes in the neighbor.
Didn't work that way in Fairfax a couple years ago.
Well, I'm sure there's examples that it does.
The law is usually not for the people who are getting along.
I think you should allow the opportunity.
But like the minimum of 60 doesn't, I'm not sure that allows the opportunity. I also am not sure, so A has unless operations shall only be imposed in the absence of conditions would result, if the absence of conditions would result in an impact of 1, 5, or 8, and then the other one is only 1 or 5.
I think aesthetics,
Yeah.
I'm guessing.
Is that aesthetics or the rest of it?
I'm guessing.
When it says 8, it means all of 8, not just a piece of it. And then so one is hours of operations, and they're both hours of operation. Deliveries. I mean, they're essentially both hours of operation.
Yeah, I didn't draft this language, and so I think it's a little it's a little confusing.
I'm confused, and I've looked at it a couple times.
I agree. Instead, so, yeah.
Why are there 4 paragraphs talking about permit conditions for forest-based enterprises? It looks like Jamie's gonna provide some insight into this, because this is, you know, like, on the face of it, pretty hard to explain.
Jamie Fido with the NRC. This is not, we didn't draft this language.
Who drafted this?
Forest Parks and Recreation.
An attorney at Forest Parks? An attorney at
Yeah,
Forest Parks?
but I mean, I'm happy to walk through those. I mean, if you'd like me to just sort of walk through the language, I'm happy to do so. I mean,
I was just gonna suggest that, and I don't wanna cut you off, Matt, because I think this is more in FPR's bailiwick. I just know from a lot of discussions we've had at the Forest Roundtable, which we convene, where we've had hours of discussion on these. The idea in B was that in the winter, you need to move wood when the environmental conditions are right to do logging. And that the delivery can be difficult, coming in at 5 o'clock and having the gate shut and then having to unload the wood and then load it back on, and it's an efficiency issue. I think the desire is to be able to move the wood efficiently when it's being cut at the right time of year. And so we've been part of discussions to try and acknowledge that there could be a benefit to that. We don't want to lose more forest processing in the state. It is important for the viability of our working lands. And if forest processing facilities are making a choice between setting up in an adjoining state versus Vermont, I think some of this is symbolic to say that we are welcoming in Vermont to try and have viable forest processing, even though the numbers may not speak to a large volume of facilities. There will be some in the future that will look at this, and there are some that may try and, through the amendment process, address this issue so that they can have a better flow of material. We thought from BNRC's perspective that it was important to have the backstop of some of these criteria in place to address valid issues that could arise from a neighbor that may be affected by noise or air pollution. The reason 8, I think, wasn't suggested under B was because when you're dealing with just the additional movement of wood, that criteria didn't seem to be as on point under the activity that was taking place in B. But that noise and air pollution were valid issues to consider if there would be some kind of undue adverse effect. I do think the language in A could be simplified a little bit. It's a little awkward the way it's worded. I'm not sure if there's any difference if it merely, Ellen, I don't know if it would be possible just to scroll up, if you even just suggest a permit restricting a forest-based enterprise hours of operations shall only be imposed if it would result in an impact under criteria pursuant. And I'm not sure if that other language is operative in some way that I'm missing.
no, I think probably.
But I think there's a way just to simplify it there, so it's clear when you're reading it what exactly it's trying to do. Anyway, I don't know if that background's helpful. I just wanted to offer some of that perspective.
Matt?
And I guess I would say, with respect to the language, oh, sorry, wrong Matt.
I'm sorry.
I'm sorry.
Go ahead, Matt. Maybe you'll answer my question.
Well, I was just going to say, with respect to the 60-day provision in subdivision B, I think that what that does is send a signal, but Representative Dolan is right. You still have to demonstrate that it doesn't create an undue impact with respect to either traffic or noise issues. I think the other operative thing that this provision does is it allows the commission to take a look at those impacts on noise and aesthetics and so forth, and balance the importance of this particular facility and these operations with respect to the forest economy as well. So it allows some of those things that historically wouldn't come in, and that's what C is effectively doing, is it allows in the undue criteria review to look at sort of the forest-based enterprise and its importance to the overall forest economy, and take that into consideration when imposing conditions.
And Jamie, can you just repeat that, your suggestion there, that
Under A, a permit
Under A.
condition restricting a forest-based enterprise's hours of operation shall only be imposed when, or if it would result in an impact under the criteria pursuant to subdivision A1, 5, or 8. I think that's what
Would that trigger a hearing?
So that would be part, yeah, we would be like part of the permit hearing process. And so when evaluating if there's an undue, we would be evaluating if there was an undue adverse impact under 1, 5, or 8. And that would trigger an hours of operation condition.
As a rule, is that a major or a minor?
Well, that depends, because some of the, I think potentially some of these forest-based might be statutorily minors, but
That's right.
so, because sawmills are by statute minors. And so it would depend.
From a couple of years ago, the legislature actually, for a certain amount of volume related to a definition based on forest processing, automatically considered a minor unless there were certain conditions that caused it to be treated as a major.
Most of the permits now granted and along those lines, minor. Jamie, you know the answer to that?
Trying to recall if the report from a couple of years ago hit on that. I don't know.
7 in 5 years at most would be kind of, should be easy to find out.
So I think, if to take a step back, I think A is trying to be a broad statement, and then B is zeroing in on hours of operation for delivery specifically, which I think is why 8 is dropped
It
off.
says ship and receive
Ship-
under B.
So movement as opposed to just operation, I think is what is happening. I think that's the difference. So broadly forest-based.
And that's trying to get to the 60 days of ground's frozen or whatever they're doing, they wanna deliver. Jim?
Two things. One, on line 1, page 60, criterion 8. There's a bunch in there, aren't there? Under 8.
Sure.
And,
Yeah.
and remind us what those all are?
Aesthetics is included, but also rare and irreplaceable areas. 8A includes necessary wildlife habitat and endangered species. And I definitely missed something
I have it.
under 8.
Yeah, 8 was the wildlife habitat, endangered species. B is, well, then it has 3 pieces, the economic, social, recreational benefit.
So it's scenic or natural beauty, aesthetics, historic sites, rare and irreplaceable natural areas is 8, and then 8A is necessary wildlife habitat and endangered species. Noise is aesthetic noise is under 8. Health-related noise is under 1.
I wonder if we need a little parsing out of that 8 and ditching the stuff that really isn't gonna apply to a wood processing business. But
So it is say, I'm not sure if we need to, because it's saying you can only add hours of operation conditions if an adverse impact is found under
okay.
8. And so are you worried that for necessary wildlife habitat someone would include hours of operation?
Right, no, good point. On to the second
I
item.
think that they might need to, if there's an endangered species that needs to sleep. I don't know. I mean,
Yeah. So leaving 8 on line 1 as is would appear to be reasonable. My second is back on 60 days. For a minimum of 60 days, and we're doing it because, you know, the ground needs to be frozen. We have to have snow to skid logs. We have you know, and when we have all these things in concert, we got to be able to get them to the processor. I've got all of that. I fully support that. But when we think of for a minimum of 60 days, people, we're talking about all winter. We're talking about all winter. And we could be talking about all summer, because if it's a minimum of 60 days, it could be 360 days. I'm just saying. I think that language is like inappropriate. For a minimum of 60 days? Like all winter? Okay. But I would change that to a maximum of 60 days. Or if we want to give them all winter, give them mud season as well. And make it 90 days with a maximum. So minimum of 60, maximum of 90. Minimum of 60, maximum of 70, 80. This is carte blanche, as written, I think.
Just a point of clarification. The overall permit also includes a provision that says for an additional minimum of 60 days, I can do X for delivery. If I exceed those 60 days, do I have to go back and get a new permit?
Not with the word minimum, I don't think.
I'm asking the question.
Oh, I see.
Well, so if you violate your permit, so if you
No,
exceed.
I'm not saying that. I'm saying that permit, one of the conditions of the permit says for a minimum of 60 days over and above normal hours of operation, I can take advantage of the environmental conditions to ship or receive. My question is, the permit's basically saying you got 60 days to work with. If I go to 61 days, do I have to go get an update to my permit? Yes. Okay.
Yes, you do.
Opposite.
I mean, if your permit requires 60 days, I mean, so again, what this is in, just again, not to go back, I think, yes, it says a maximum of, or a minimum of 60 days. I think it also requires the review under criterion 1 and 5. So I appreciate people are seeing minimum and very focused on that. It still does require the review that would typically happen on hours of operation under the criteria. Though again, C modifies that review slightly so that it can take more things into consideration when the district commission is doing that or the board is doing that.
Carrie.
I mean, when you think about what 60 days, this is above the normal work week. Well, and if you try to break that down, assuming that we don't have January thaw, or it only occurs once in January, that 60 days works out to be more or less 3 or 4 months where you have extended hours, maybe on a Saturday. If it's 2 days, you know, on a cold, your ground's frozen, maybe they take advantage of that. But our winter is typically from, you know, November to February, good winter with shoulder seasons. That's your 4 months. So, I think the language is fine here because of the unless, and then this does, I think, send an important message, as Mr. Fidel had pointed out. There's still recourse if the impacts are significant. So I accept this compromise language.
Mr. Weiss?
Thomas Weiss, resident Montpelier. I look at this in terms of my construction contract and construction background, and the way I could interpret this is that if I put a condition into the contract that limits hours for days going outside those hours of operation, I can't say you can go So if I put in a number that says you can work outside the hours of operation on a certain number of days per year, that certain number of days cannot be less than 60. So I could put in, you can only work 60, you can only work 75 outside the hours of operation. And that's how I would interpret this, as you can't have it less than that number. But I don't know how the attorneys in here would interpret it in terms of what I've just tried to explain, and I don't know that I'm making myself clear.
Carol?
I kind of get, I think, what you're saying, and I'm thinking that maybe we just shouldn't have to be in here, or, I mean, if we have to, I don't think this is clear enough.
I think it's clear enough because you're stopping at 60. You're saying for a minimum of 60 days and then stop. So, but you got to read the whole thing. You know, for a minimum of days per year, unless there would be an impact. So you know, to me it is clear.
Yeah. And do you support it?
Sure. Yeah.
But he's saying how you count the
Right. No, I get it. And but yeah, right. So it could be 60 days, and I
Evan,
guess that's supposed to be
Maybe it doesn't
are you
matter.
aware of other permit conditions that have enforcement agencies or neighbors counting numbers of days like this for hours of operation? How would this be done? How would this be enforced?
Yeah, so the closest thing that I can think of right now is things like truck trips.
Yeah.
Sometimes there's truck trip limitations imposed to mitigate things like traffic impacts.
Right.
And occasionally we do have a very observant neighbor who takes lots of pictures and photographs and sends us lots of emails and is very helpful in flagging when a permittee is operating in excess of their allotted truck trips or even their hours of operations.
Okay.
And that's generally how we do it.
Sort of like other criteria.
That's exactly right.
Okay. Thank you. All right, Kenny, we gotta move on. So,
Yep.
general consensus on this one.
I'm falling off of my sword. Let's move on.
Wore him out.
Leave it as it is.
Yeah, it's, let's leave it.
Fine.
Move on.
See that.
All right. Closed.
How's that, Chris?
I had a note here until the 9 minutes.
Actually, though, sorry, on page 61, I'm not sure we got to this paragraph 4. Sorry if we did, but
Yeah.
we were so focused on.
I mean, we didn't even get to paragraph 3.
Oh,
Yeah.
let's get to paragraph 3.
Sure.
Oh yeah.
Permit conditions on the delivery of wood fuels used for heat. Permits issued for a forest-based enterprise that produces wood chips, pellets, cordwood, and other fuel wood used for heat shall authorize the shipment from the enterprise of wood heat fuels to the end user during hours outside permitted hours of operation, including nights, weekends, holidays from October 1 through April 30th of every year.
This was the one.
We've got all kinds of questions on this.
Definition for permitted hours of operation, because it showed up in B, and I'm starting to wonder what's that.
Well, I mean, there isn't a definition. I think I have trouble with that phrase also because permitted here is sort of an adjective,
Meaning allowed.
or is it from the permit?
Yeah.
So I
Well, and if you're giving 60 days outside of the hours
Yeah.
of operation,
So
what
I
are
would-
the hours of operation?
Right.
This
That's-
is circular.
Hours of
This is
operation,
a mess.
it's a big problem here, I'm having a problem.
so right.
So, all right. Maybe we should let the Senate take this one.
That's what I was, they might not.
All right.
So no, there is no
Okay.
stated definition.
Well, I kinda need a definition.
So here's what I'm gonna say though to the attorneys in the room on the language of the first few paragraphs which we just talked about. It needs to be simplified and clarified. Jamie said something that helped
Do you,
clarify.
do you want me to draft something?
Sure.
Okay.
That meets this intent, that is fewer words and more clear, would be very helpful. I mean, more clear is the goal, but I have a feeling with this one, with hours and hours in the same sentence, this paragraph we're on now, I think maybe we could use fewer words too. Okay. Paul's gonna offer it in writing expertise.
Yeah, I need to know what permitted hours.
What are permitted hours of operation when we're talking about granting a permit for
Yeah.
hours of operation?
Well, I'm not gonna use that phrase when I draft it, so.
Okay.
Well,
Thank you,
thank
dear.
you
Thank you.
very much.
I'll use
Something else.
less words.
Less is more.
Too many notes.
But even I don't even know
Alright.
what they're pointing at.
So let's
I-
get to the content of 3. While we do Doug first. Matt.
Speaking of the content of 3, I think we heard testimony that what often happens is a very large truck that gets filled up, and the places are often in a very large parking lot where they have to get the truck into. Therefore, they don't do it in the middle of the day. They do it after
When the parking
when
lot's
it's dark. Yeah, and that was the point of this. And they also got to do it. They also got to do it quickly because they can't leave it on the truck overnight. Is what I think we remember.
chips would freeze.
The chips would freeze, and you have a giant block of wood that you couldn't get rid of.
Right.
So that was what I remember that being in there
Yeah.
for.
It's hard to get that into the auger.
The hours outside of permitted hours. Okay, you can fix this hours outside of permitted hours also?
I mean, it does sound as though they're asking to override the permitted hours and just have a set, from October 1 to April 30. So,
Exemption.
What they really, yeah, I mean, is
They mean
they
they wanna
wanna
be
do it
exempt from
whenever they
permitted
want.
hours during
during-
October 30th.
Yes.
Right, from October 1st to April 30th, you do it at whatever hour you wanna do it. That's what it's saying.
And do we support that?
Yeah, so now we can talk about it.
It is the winter months, you know, it's kind of.
Yeah,
what's
I'm
needed.
not being against it, I'm just saying that's what it's really saying. We
Yeah.
wanna do what we wanna do when we wanna do it, okay.
Well, because they kind of have to.
Yeah,
When it's
I'm
cold-
not
when it's
being
cold
mean about
outside.
it, I'm just saying that's what it's saying, instead of saying permitted hours, because we don't even know what that
Right.
is.
You want your language in there?
No, that would be something I said to my kids,
Oh.
you wanna do it. But thank you anyway.
Where are we? Are we ready to move on this one? We'll get clarified. Let's keep going.
Forest-based enterprises holding a permit may request an amendment to existing permit conditions related to hours of operation and seasonal restrictions to be consistent with the subdivisions above. Requests for condition amendments under this subsection shall not be subject to Act 50 Rule 34E, which is what they currently would have to go through in order to get their permit conditions changed.
What,
So this is just saying, if you enact these sets of conditions for permit conditions for forest-based enterprises, they don't have to go through the 43E process to get their permit conditions changed. They can
34E
audit.
process.
Yeah,
But
to match.
what is the 34E process? I mean, I get the
It's
rest of it.
it's a standard
Yeah,
notice.
so Rule 34E codifies a ruling from case law that talks about when a permittee can go back and get a permit amendment. And it sets a certain threshold that they have to establish, that they're not just asking, basically they're not just asking the commission to change it because the applicant's saying pretty please. They have to show they're not just trying to relitigate the underlying case all over again, and it sets forth a number of factors that the commission has to consider before agreeing to even entertain an application for a land use permit amendment.
Would you be able to help us understand some of those conditions? Like, why shouldn't they be subject to it?
Why shouldn't?
This request for an amendment for forest-based products not be subject to 34E?
Because there has to be a change,
Yeah,
right?
I mean, that's more of a policy consideration than a legal
So
consideration.
34E requires some sort of a bigger change.
No, we wouldn't have to change, if the committee were to decide just to accept this proposal as written, there would not have to be a change to Rule 34E.
I understand. I'm trying to understand why they need an exemption
Oh.
from 34E. What is this fear of 34E?
I think that's probably a question for FPR and the forest products industry. It's,
From my reading, since we've already laid out the terms of operations under 2 and 3, going through Rule 34E would be redundant.
yeah,
or given?
I mean, this is saying that they would not have to.
We've already laid out what the terms.
Well, what it's saying, what this section on the top of page 61 is saying is, if you've already got a forest-based enterprise business and you're operating and you've got limitations on your hours of operation and you want to take advantage of these new statutory changes, you can go to a district commission and ask for a land use permit amendment, and you don't have to pass 34E to make it happen. In other words, you can just walk in the door and ask for permission to be, for your business to be treated under this new statutory provision, rather than the statutory provision that was in place when you first got your permit.
Peter, did you want to add anything? We get that part, but no one's telling me what 34E actually requires. Could someone
Well,
just tell me what 34E
yeah,
makes
so-
an applicant go through?
So what 34E says is, when the commission gets an application for a land use permit amendment, they have to first decide whether or not the amendment seeks to change a permit condition that resolved some sort of critical issue to the original permitting process. If the answer is no, then the commission can just take up the application. If the answer is yes, there will be a change to some critical permit condition, then the commission needs to decide whether or not the applicant is essentially just trying to relitigate the original case. In other words, a critical issue was impacts on deer wintering area. The commission imposed a condition that said, don't impact the deer wintering area. 5 years later, the applicant comes back and says, I want to cut down the deer wintering area, and there's been no change to justify it. They just are asking again. They're just coming back and re-asking for approval, even though nothing has changed. If they're not attempting to relitigate the issue, then there's this balancing test that the commission needs to weigh. It's called balancing flexibility versus finality, and it's a pretty well-established test that the courts and the commissions are used to applying. And in that balancing test, there are several factors to consider: changes in facts, laws, or regulation beyond the permittee's control, changes in technology, construction, or operations, other factors including innovative alternative designs that provide more efficient means to mitigate project impacts, policy considerations, including proposed amendments that further the goals of duly adopted municipal plans, any manifest errors that the district commission might have made, and the list goes on. There's 2 or 3 others.
That's all still in 34E.
That's all in 34E.
Okay, thank you.
Evan, so if you were to go through this, if you were the owner and wanted to amend the conditions, you would first go to, you would have to convene the commission in order to hear what you want to do? Or would you go through district coordinator?
What you would do is you would prepare a land use permit amendment application. You would submit it just like you would any other application, and then the commission would have to decide, just like normal course, are we going to treat this as an administrative amendment, a minor, or a major? And the process would play out just like it does for any other permit amendment, except you don't have to do 3040.
Okay, thank you. That's helpful. So for the 3 permitted projects that happened in the last 5 years, do we want to amend statute? Sorry, I love exemptions.
Were they all received? Were they all?
Yes, but they had limits on the hours of operation and traffic. 2 had limits on hours of operation, 1 had limits on traffic.
And
Could you rephrase that question? You're talking about amending the statute?
That's what we're talking about.
Yeah, yeah, but you're asking, do we want to do that?
Yeah.
Is there any other way?
Well, they could apply for an amendment without this paragraph.
the only thing I would say is, are they not applying for amendments because they don't want to go through the process and are worried about it? Or anytime they want an amendment, they just go pop up and they just apply
This is
for
contingent
it.
on us making the previous changes.
Yeah. agree with you. I don't have
Jim just stated it.
Peter?
Just Peter Warren, for the record, I would just make the argument that you are setting the public policy for the state of Vermont that we want to support these sorts of changes to permitting conditions. If we want to do that, then we should be considering not just the ones that are coming up for permitting review, but those who have gone through. And this is a way to indicate that we want to make, we've stated that we've done the balancing test, you have done the balancing test for the district commissions, and so therefore that level of review isn't necessary, is essentially what you would be saying.
And without this, we could be potentially treating existing permit holders and new permit holders differently if we don't do this, correct? And I know many of our forest products industry are, been around for a while.
I like the language in the bill.
This is.
And then I'd make a point just to underline, this is specific to hours of operation and seasonal restrictions, so it is narrowly defined.
I can hear Karen.
It's
sorry.
narrowly defined because it does talk about, it's for specific to hours of operation and seasonal restrictions.
Yeah.
So I'm okay with the joint language.
Okay, let's move on.
Right. Other permits and approvals, presumptions. So this is the section about permit presumptions. So what is in your bill currently has been in your bill for a long time. I do have a note that there is a difference in the joint proposal that would change this line 6 and 7. So the joint proposal language that would allow all A&R permits to have permit presumptions, the change would happen on line 7 so that it would read, the board shall allow by rule, or shall by rule allow the acceptance of permit or permits by the following. So that's not in your bill currently, but that was in the joint proposal. So that all A&R permits don't have to go through the rulemaking process before the Natural Resources Board to get the presumption.
So, Billy did send a list today. Did you post that, Mark?
Really, yeah.
Should be under Billy Coster. I don't know, it looks like, so it's all the permits and, whether or not they've gone through the NRB rulemaking. Which is 19E2A, I guess, but then maybe did they, Evan and, Evan, I can't see, yeah, sorry, I can't see right. So, this has authority column and it says 10 VSA subsection 556 NRB rule 19E2A. Does that mean it's been approved by the NRB by rulemaking? Are you looking it up, Ellen? Could you put it up?
Oh, sure, sorry.
So it's on.
Yeah, I'm not sure we've seen what we're referring to right now.
It's about to be up on the screen.
Oh, all right. Okay, so can you repeat your question, please?
I just want to understand what authority means in the column there. So, just so we, for the record, are clear. What does that mean? It looks like the first green ones went through NRB rule 19E2A, but then there's 19E 1B, is that another NRB rule? These are starting with the list of permits that have been approved through rulemaking at the NRB under 2 different rules. I don't know if we need to understand the difference between those two, or if it was.
Yeah. It would take a little time to take a look and see what is in this document and compare it to our Rule 19 to see which permits are covered under our current rule.
Okay, well, I'm not, but I'm just asking at a higher level to understand what they're saying here.
So for the record, Matt Chapman from A&R. So yes, so basically what that the authority line cites to the authority for the permitting program, and then it provides the provision of Rule 19, which is the presumption rule, that particular permitting program is given a presumptive status, and then just basically answers the question, is this a rebuttable permit? Yes, no, right? So the last column is kind of the simple column. Does this get a rebuttable presumption?
And it's
Yes,
rebuttable
no.
if it's gone through rulemaking.
Correct.
Thank you.
And Rule 19 is the rule, and the subdivisions are basically sort of where it is at in Rule 19. And so Billy and a couple of others and I went through Rule 19 and sort of categorized these.
What's the color coding?
Please don't pay attention to the color coding. What? I know. So this is why you don't have lawyers do pretty things. So I ended up no, this lawyer do pretty things. It ended up there were some issues with respect to me trying to change the colors, and it didn't work.
Okay, so the colors mean nothing.
The colors mean nothing.
Pay no attention.
Pay no attention. Kind of. Yes.
Okay.
One was air and one was water.
So I would just ask Matt, if it says no and it hasn't gone through NRB rulemaking, is that by definition because you're waiting to lump them all together and do them as a bulk? No, some of them don't ever go through the process.
So there is, as you go through, you'll see groups of these permits. Now, some of them, I can't really speak sort of conclusively. There are, some of these permits have been around for a while. The board has not amended its rules.
Since when has it?
That's been quite a while since the Rule 19 presumptions has been amended.
Right.
A number of years. In fact, I think some of the permits are referred to as by different names now. So it's been some time.
And I think
they could use an
5
update.
years? 10 years?
Probably on the order of 10, I'd imagine. Not in the last 6 years, I know that for certain.
And to some degree, this is, it's trying to do the, for lack of a better word, good government thing of if you're going to use your permits as presumptions in these proceedings and you've gone through this, and the board, it's a burden on the board to go through rulemaking as the legislature expands permitting jurisdiction and authority. Not changing the weight of what those presumptions are given or how Act 250 reviews them, just making sure that the universe is complete with respect to the permits and the presumptions that they're given.
Questions on this?
Is this, where is this?
It's under Billy Coster.
Today?
Well, yes, or today and by his name. Good, thank you. Yeah.
Are we really looking at a decision as to whether or not we should replace may with shall?
Yes.
It'd be line 7 on page 61. Yes?
Yes.
So what happens when a rule goes through this rulemaking? I know you haven't been there when it happened, but in theory, what does the board look at?
I would imagine the board would look at the permit at issue and try to determine specifically which criteria it aligns with. And we would probably look as well at the permitting process at A&R or another state entity to make sure that it's robust enough to satisfy the requirements of Act 250.
And so by not directing where a permit, which criteria a permit would be linked to, I mean, if it is linked, does that limit it? Or if it's not linked, does it do something else?
So, and I guess the question is, can a certain A&R permit be used for more than one criteria if it's not specifically linked to a specific sub-criteria? And I think generally the answer is likely yes, that it could be. I mean, I think most often there are certain A&R permits, for instance, a wetlands permit that is generally linked to criteria 1G, which is our wetlands criteria, or a stormwater permit might be linked to our criteria 1B, which deals with that provision of wastewater. But theoretically, I think ancillary A&R permits could satisfy some portions of other criteria, namely, for instance, criteria 1 more generally, which is the broader look at water and air, not just specifically wetlands, stormwater, wastewater, etc.
And so just to add to that, Rule 19, when it lists all of the ancillary permits that create presumptions, it's not really organized by criteria, it's organized by subject matter. And so, for example, there was just a court filing that we made earlier this week that said, yeah, A&R stormwater permits create presumptions under both criterion 1 and 1B. So it's definitely possible that could be true.
Sorry, there was just what this week?
So we just filed something in with the court today. It's a matter of public record where we took the position that an A&R stormwater permit created a presumption under criterion 1 and 1B.
Okay.
But just to be clear, that A&R permit wouldn't necessarily satisfy the entirety of criteria 1, or maybe even the entirety of criteria 1B.
Yeah.
It would satisfy just the portion of criteria 1 that deals with stormwater, for instance.
Do you imagine that if we have the professional board operating, that they would be more inclined to go through this rulemaking more regularly?
It's a matter of resources, I suspect. It's certainly something that we can do, and I think that you, as the legislative body, could require us to go through and update our rules every X amount of time, X amount of years, if you think that's necessary. But again, I think it all comes back to the resources at the end of the day.
A minimum of 60 years. Couldn't help myself, man.
So essentially, what this process does is it gives the rebuttable presumption to the A&R permit if it goes through the rulemaking. That's the standard that we are, in our underlying bill, we were going to have for permits, is the rebuttable presumption.
The joint language does speak to that, saying that, on looking at the joint language, this is our existing language.
Right, so what page on the side?
Page 22, where it does talk about the presumption established by this subdivision 1 shall only apply to the issues addressed as a part of the terms of the permit. And that's, I think this is why I did quite a bit of work comparing the two. And if we were to go with the applying a rebuttable presumption and using the word shall, I appreciated the organization and the fact that it does clarify that what the presumption would apply to. I think that's important. We don't have that language in others. And we show that in two places, one under A, under state permits, and then I think I found it helpful to separate state and municipal permits. It's well organized this way and helps to provide clarity so that if you're, and it helps separate them out. Noting that the municipal government related permits, the board may by rule allow a permit specified by a local government in lieu of evidence by the applicant, so that it treats the municipal permit differently from the state permit.
So your bill separates state from municipal permits currently. It doesn't have the intro headers, so I can add that if you would like, but subsection 4 talks about municipal permits, but the subsection 1A talks about that. So it's a slight difference in alignment, but they are broken into state and municipal.
Thoughts?
And the language on page 61 does reflect what you were talking about for specific requirements. So I think those two things at least are addressed in.
I think they're pretty similar. I thought the difference was about this request and not about this chart. Is that, am I there?
I think there are two, there's actually more significantly different when you get onto some of the changes that are proposed in the bill that the committee is looking at.
Right, so there is the whole section about A&R permits.
Right. So
Are we there yet?
Not quite. So the first part, the joint proposal is all permits don't have to go through the rulemaking, they just get the presumption. Yours goes in a different direction because it talks about whether or not a permit is part of a program that reliably meets its goals. So that language is on page 62. So the rules adopted by the board shall not approve the acceptance of a permit or approval of such an agency or a permit of a municipal government unless each of the following applies. The permit or approval satisfies the appropriate requirements of subsection A of this section. The board finds that the permit or approval is part of a program that reliably meets its goals, such as achieving water quality standards. A permit presumption created under this subsection may be rebutted by the introduction of evidence contrary to the presumed fact. And then, in the case of approvals and permits issued by the Agency of Natural Resources, there shall be no presumption for a permit or approval authorizing the discharge of a pollutant into a water if uses of that water are already impaired by the pollutant. Admissible evidence of the technical determinations of the agency shall be accorded substantial deference by the district commissions. So there are multiple proposals in there, but they were part of the larger discussion at the Commission on Act 250 process regarding water quality issues and whether and to what extent Agency of Natural Resources permits should be given presumptions, particularly if they're meeting the goals of their permit program. It also lowers the presumption standard slightly, so that this is sub 2 on line 17, may be rebutted by the introduction of evidence contrary to the presumed fact. That's a slight lowering because rebutting a presumption is actually a pretty high bar to meet in some cases. So there are multiple proposals in this. Do you want me to focus on one, or how do you want to start?
I guess it's hard because we have that's a good suggestion. CO2 levels have been high in our room for the last hour and a half. So I do recommend opening more windows and getting more oxygen in the room. And let's take a 10-minute break before we hurt our heads more talking about permit presumption.